Oh, yeah. Oh, that's right.
It's just not policy.
Yeah. 20%
Yeah, pretty much. Yeah, nobody's gonna. Yeah. Just don't want to have to stay here until 2:30 at night.
Could be one, but no, two of them, yeah.
We gotta help you. I call directions pretty darn good. You just don't know what to do. I'll help you. Yeah.
Are parties permitted to sit up with counsel? What's that?
Yeah.
Okay, thank you.
Probably 6 feet.
Sure.
Let me just say to you all that it is the witching hour, but we're waiting for the applicant's counsel we have asked to contact his client about an issue that arose. So that's why we're not starting on time. We'll start as soon as he returns.
I see you're like, "Kid, you have to be
36 years. Oh, wow. I'm in my 30s. Thanks, though.
And how? You know she's gonna sit. Where's Todd?
Just so you gentlemen know, you did be keeping the blue button, your light turns on, then turn it off, you don't have any feedback. John, very similar, you put yourself on mute, right? I'm so glad we could put Ross on mute.
Mr. Nervo, are you ready to proceed?
I need 5 minutes, please, Mr. Chairman.
Getting away with this.
So,
Olivia is running 3 miles race. 3-day race. 3-mile race. 3-day race. In 3 miles. They run around, they just 1 mile circle to see how many miles they can do.
A 72-hour race. Circles in the-
Yeah. I said, I'm running to do the goal 2 miles. I know.
Goals around 200
Because she wants to do a 200-mile race.
miles.
I just, you know,
Wow.
80 miles, 70 miles, 3 15 miles.
it's okay. Does it have a long?
The witnesses stand here.
It's always an adventure.
That's what witnesses.
So, see, that's the-
Yes, this is for the public
The camera
hearing.
can hear.
Okay. Actually, I might just slide it down.
But also, have to talk to
Okay. Okay.
Yeah, so everyone's gonna have to use their mic.
Okay, well,
Just push the button.
All right, we're gonna, bring this proceeding to order. This is a public hearing of the East Ocean Township zoning hearing board. I have a feeling that everyone here this evening has a vague notion of why we're here. But this is the application of the Malvern Institute, a medical treatment facility for substance abuse disorders on the south side of King Road, just east of its intersection with 352. This application was before this board in 2018, and in fact, at that time, we held 6 extended sessions of a public hearing in the first 9 months of 2018, between January and September. That was 2 years ago. At the end of that process, we entered a decision. And we denied the application as it was filed, and we asked the Institute to return to the board to select from the 2 applications that had been submitted. The Institute took an appeal, as was its right, and the matter was heard by the Court of Common Pleas of Chester County, and ultimately that court sent it back here, and so we have returned. We were ordered by the court to hold a hearing, make findings, and issue a decision consistent with the court's decision, and that's what we'll do. And that's why we're here. At the front of the table, on the far right, is our solicitor, Mr. Andrew, Mr. Ruggiero, Mr. Roberts, and myself on the board. We met back in February in this matter, although I don't think we took any testimony at that time. It was the board as it's constituted now, but I would ask, because, only because of the vagaries of my memory, I would ask the council that are here today whether they would agree on the record that the board members before you will hear and decide this case. I say that because we do have two new board members who were not here 2 years ago when the record was made. So, Mr. Nicholas, is that acceptable to your client?
Yes, it is.
And Ms. Cato?
Yes, it is.
And Mr. Christman?
Yes, Mr. Chairman.
I am not altogether certain what ground we have to cover this evening. I understand from a recent email from Mr. Nagel that the revised proposal, which is the subject of much discussion in the decision of this board and the decision of the court, that proposal is no longer before us. Is that correct?
Mr. Chairman, I think I would cover that if you would allow me to articulate my client's full position as where we are. I think I would include an answer to that question, but I'd like to do it in context rather than a simple yes or no.
Right, well, we'll come back to you then, Mr. Nagel. Thank you.
Thank you.
I'm also not completely clear on what the evidentiary position of the township or of the neighbors is, but we'll come to that. For the moment, I would ask that our solicitor mark the board's exhibits, and then when we're done with that, we'll come back to Mr. Nagel and we'll let him begin to present his case on behalf of the applicant. Mr. Unruh?
Yes, the first exhibit will be B18, which is the proof of publication, which basically is similar to the initial advertisement, a public notice for the hearings that have already occurred, even though the scope of this hearing is very limited to the determination of which of the alternatives to be selected, because the court basically decided that the applicant was entitled to the requested relief, which is essentially approval. B19 is an affidavit of posting. B20 is the public notice sent out to the neighbors with the attached list of all neighbors to which the notice is sent. I also have an exhibit that I received from Mr. Gordon, and I don't know, Kristen, were you going to introduce that as exhibit T2, or would be just happy for me to do so?
Just as happy for you to do so.
Okay, I received from Mr. Gordon a letter dated September 22, 2020, from Mr. Gordon, which basically sets forth the board supervisor position. Since, and I marked it at T2, and since folks in the audience may not know what that says, I shall read it. Dear board members, at their meeting on September 15, 2020, the Board of Supervisors unanimously approved the following motion. Quote, Mr. Chairman, I move that the Board of Supervisors recommend that the zoning hearing board consider the Board of Supervisors' recommendations outlined in its February 7, 2018 letter to the zoning hearing board. Additionally, if the zoning hearing board decides to approve the original proposal for the second-story expansion above the existing one-story area of the facility, the Board of Supervisors will recommend that the conditions outlined in the February 7, 2018 Board of Supervisors letter be imposed for that proposal. And I will enter in that T2 into the record.
Or you want it to be T2 or CHB, B21?
I'm sorry?
Did you want it to be T2 or the board exhibit 21?
I consider that to be a township exhibit.
Okay, that's fine.
So I was going to mark the T2.
That's fine. And I'll hand a copy to the court order.
And Mr. Unruh, the letter that you just marked as T2 as an attachment. The attachment is the letter that's referred to in the text, the February 7th, 2018 letter, also to this board from the governing body. And it's 5 pages in length and contains a description of 28 conditions. The board asks in the letter you read to be imposed, that now read, to be imposed, that now read.
That's my understanding, and it would be perfectly applicable to the one-story alternative, and all but condition 4 would be proposed to be applicable to the two-story.
I'm sure we'll hear more about that. Are those the exhibits?
They are.
Mr. Nagel, would you tell us what you plan to do with the applicants?
Yes, Mr. Chairman, good evening, my name is Ryan Nagel, I represent the applicant. Obviously, this has been a long road in this application, and everybody knows that my client is dying on the vine in need of an expansion. While my client was happy to advance the first-story addition plan in an effort to satisfy the township and in an attempt to create a better plan for all parties involved. At this juncture, it seems to me that my client must request that the zoning hearing board approve the second-story addition plan. When last we worked together, there was some discussion about additional testimony, potentially on the minimum relief issue as it pertains to the first-story addition plan. However, as we were put in a catch-22 situation by circumstances that I don't think anyone necessarily intended, but ultimately developed, I cannot allow my client to be in that situation again. And I fear that asking the board to approve the first-story addition plan in accordance with the township's wishes will put my client right back in that situation, because obviously there's a plan with lesser square footage that my client has testified will satisfy its needs for expansion. I still maintain that there's an argument that and it may be a novel argument and there may be no case law on point at this time, but I still maintain that the improvements for the benefit of the neighbors can be weighed against the increased size of the first-story addition plan as compared to the second-story addition plan, and can relieve the zoning hearing board of the minimum relief, what I'll call the minimum relief conundrum. However, I cannot allow my client to take the risk that goes to the Commonwealth Court on what I believe at this point to be a relatively novel issue. I submit that the appellate court, the Court of Common Pleas, in this zoning matter's direction is that the relief be granted to my client. Since I'm requesting that the second-story addition plan be approved in conjunction with the application, I don't believe there's a need for any additional testimony on the minimum relief issue, and therefore I don't plan to present any additional testimony this evening. I only request that the zoning hearing board approve the second-story addition plan so that my client can move forward with their expansion and in accordance with the direction of Judge Connect. I wouldn't, however, sorry, Mr. Chairman, one last thought. I wouldn't, however, characterize that as I'm attempting to amend or withdraw the alternative plan. I don't think that's fair to the board. I don't think that's fair to the township. And so I won't do that. But I made my request nevertheless.
I think I understand that. Ms. Camp, what's the township's position on all this?
Well, as indicated on Exhibit T2, the Board of Supervisors' position is the same as it was stated at the zoning hearings. They did render any opinions or take a position on any of the legal relief sought. They thought that was in the zoning hearing board's jurisdiction. The court has now answered that question for you, and I also read the judge's order indicating that the applicant is entitled to relief. I think the judge left it to you to decide which plan should be approved. The Board of Supervisors, as indicated in the letter of February 7th, 2018, which was Exhibit T1, one of the conditions is it prefers first-story addition. I understand the legal, the issue that is presented in that the zoning hearing board potentially would find that the applicant then has not met its burden to demonstrate the fifth criteria of a variance. But I think in a non-conforming expansion case, I think there is testimony in the record that was presented by the applicant that they themselves recognize that the first-story addition gives them the programmatic needs and additional area within the basement of the first-story addition. That is actually a better plan for them in terms of what they need to continue to exist as a treatment center in today's society. Their witnesses testified about that the alternative proposal offers a better space for programming, and that's all the notes of testimony at page 245 through 256. The township believes that the alternative proposal represents a better plan that will mitigate the impact on the neighbors by blocking their view of events that occur on the property, while also at the same time providing the applicant with more space to provide modern treatment such as a small workout room, theater and community room, lifestyle classrooms, admissions and orientation offices, and staff offices.
But Ms. Camp, it is in your view a better plan, but a better plan that the applicant's no longer asking us to approve.
Well, I don't think that's fair. I think that had that been a position taken during the zoning hearings, the township would have presented a different case. So I don't think that at this point in time, they can, and he's saying, he's sort of parsing his words here. I mean, he effectively is withdrawing the alternative proposal, and that's not what he presented to the planning commission or to the board of supervisors. So I think the board of supervisors would have put on a different case had that been the position they took throughout the hearings.
Well, that may well be, but the court has set it back here for us to grant some relief, but we're not going to approve, at least I'm not going to make a motion or vote for approval of a plan that the applicant isn't asking us to approve.
So I think that, again, I think that's legally not correct on behalf of the applicant to do that. I think they're baiting and switching, but if the board believes that the original proposal is what needs to be approved, then the township board of supervisors thinks that all of those conditions, obviously except for condition 4, needs to be imposed. And I'd ask the applicant to agree to that on the record.
Mr. Chairman, may I interrupt, please? This is Bill Chrisman on behalf.
Hold on, Mr. Chrisman. There's a question that's been asked to me. I'd like to answer it before I forget what it is.
The question was whether you can agree to the 28 conditions less number 4. If this board were to approve.
To answer the question,
I will just note for the record that the township residents and neighbors of the facility have an opinion on those conditions.
I understand that.
Okay,
I understand
thanks.
that. We're trying to find out where the applicant is on this issue, and then we'll hear from you and your client.
Thank you, Mr. Chairman.
Mr. Nagy.
first of all, I need to say that I don't think it's fair to characterize my client's position as a bait and switch. My client, I don't think, certainly my client, but maybe I could have anticipated the eventualities, although that I submit would have been difficult. But when the alternative plan was suggested by the Township Planning Commission, accepted by my client as an alternative plan and included in the context of the hearing, including with separate evidence, testimony, paid for engineering work, architect work for both plans to try to come up with a better plan, that they would have anticipated that they would be back here with the potential for an appeal that would go to the Commonwealth Court in the context of another decision from the trial court talking about the minimum release standard and a decision from the zoning hearing board also covering that subject, with the prospect of going back up to the Commonwealth Court again, all the while, as time goes by, they're, as I said before, dying on the vine over there, in desperate need of an expansion to survive. So I think that's an unfair characterization. However, to answer the question, and I will also acknowledge that my client believes that the first story addition plan is a better plan. It's better for better for the township because it's what they want, and it's better for the neighbors, in our opinion. But that hasn't been accepted by all the parties involved in this case. And so I feel as though, and my client feels as though, their hands are tied. I will say that my client would be willing to accept the conditions set forth in the February 7, 2018 letter that was sent to this zoning hearing board by Mr. Smith, the township manager, with a few minor proposed changes, and I think we already acknowledged that condition number 4 would be off the table.
Well, the township's not asking the board to impose condition number 4. Whether it's off the table or not, another question.
Fair point, Mr. Chairman. In condition number 3, the applicant shall have, down in the third sentence, I believe, or the fourth, the applicant shall have no less than one security guard. What they're required to do now is to have a MOAB trained technician, which essentially has training similar to a security guard, but has further training that specifically relates to dealing with the population that my client serves. And they under their current insurance requirements, they can no longer continually monitor the security cameras. They have to monitor the security cameras in accordance with their updated hourly rounding plan, which actually involves more active physical monitoring of the patients at the facility. The only other condition that I would object to at this juncture is condition number 26. But short of those two, and I can explain my reasoning if you want to hear it, but
I'm sorry, which number was that?
26.
26.
What is that?
The applicant shall annually make a presentation to the Board of Supervisors at a public meeting to provide an update on the state of affairs at the facility. This report shall advise the board on the status of the expansion project, identifying the issues that the facility has encountered in the last year with neighboring property owners, and identify any new programs or policies that the facility has implemented to improve the relationship with the neighbors. We have no problem reporting to the township on that. We have no problem including the neighbors in that, but we don't believe it's appropriate to force the applicant to do that in a public meeting. So that would be our comment on that. Everything else is acceptable, even associated with the second story plan. And I would also just point out that the cost associated with a lot of those conditions was really designed in conjunction with the better plan that's more advantageous to my client. So it may be really, really difficult for them, but if the board believes they're all necessary to impose, my client will accept it.
So we will come to you in a moment. Ms. Camp, does the township agree with those revisions?
Yeah, I mean, I don't think the township believes that the acceptance of those conditions were only if the first story got approved. But yes, I think the township can live with those minor edits to those conditions.
Laura, now, Mr. Christie, I understand that you have some testimony you wish to put on. having to do with these conditions, is that correct?
Yes, sir. And if I may briefly, before we get into the conditions, I believe the original question was which plan to choose. And from the neighbor's perspective and from our perspective, I think the opinion from Judge Snell is not necessarily clear. And I think it's open, as was discussed, I understand, at the last hearing, open to a lot of different interpretations. Our interpretation obviously would be that they are not entitled to relief and that the judge ordered additional hearings, which denotes more testimony, in order to make sure that the applicant had proven their case as it relates to the guidance put forth in the decision. Based on that, I will say, if I understand the board has not taken that position, but it's clear that there's no possible way the board could approve the second plan, the alternative plan, that is the one-story addition, because it requires so much more additional relief. So therefore, it doesn't meet the minimum required. And so I heard Ms. Camp mention that these conditions in the township's case was based on the alternative plan and not necessarily on the original plan. So I invite the township.
No, that's not what I said. I did not say that, Mr. Christman.
I'm sorry, I misheard you then. It sounded as though you stated that, okay?
No, what I said was, what my last statement was, I did not believe that the applicant's acceptance of these conditions was only specific to the original plan. I thought it was more generally to whichever plan the alternative plan. Whichever plan got approved, I believe, the alternative plan. Whichever plan got approved, I believe that these conditions came about as a result of numerous meetings with the planning commission and numerous meetings with board supervisors.
But did you not also say that the township may have taken a different position if the applicant was only going after the first plan?
If at the hearings, the applicant only presented its original proposal, the township very well may have put on a different case.
Then I would invite the township to in fact put on that case.
I don't believe the court order gives us the right to do that right now. I don't read the court order the way you do. And the township does not need to do that right now. I'm just stating the position.
I'm just inviting you to do so because it is the way that we interpret the decision. If the board does not choose to go in that route, that's fine.
We disagree with that interpretation.
Well,
And I would-
for myself, I'm much less interested in how we got to here than where we are at this moment. And if I understand the applicant and the township, whatever they thought about these conditions in the past, they're agreeable to them now with the exceptions that we put on the record. So, as far as I'm concerned, I'm not sure it helps us to try to figure out whether that would have been true if things had been otherwise. And in any event, Mr. Christman, you have evidence to put on? Is that correct?
We would like to put forth some testimony relating to the proposed conditions. We think that some of those need to be altered in some form or fashion in order to help protect the residents of East Goshen Township.
Okay, so if I understand you, the conditions that have been agreed to by the applicant and the township are not entirely agreeable to your client.
That is correct.
And that's what you're going to explain to the board through testimony.
I would like to put on some testimony, so if the board were to, in fact, impose those conditions against the applicant's will, there are some findings of fact that can go along with those conditions.
I don't think we're going to be imposing anything against anybody's will unless you're asking that they be revised. So,
I am asking, in fact, we will be asking that some of these conditions be revised, that is correct. And I'm sorry to put words in Mr. Nagel's mouth, but I assume you would not agree to them.
does anyone have any objection to that testimony coming in at this time?
I have an objection to any additional testimony. There's no new or additional evidence being presented this evening for the applicant. The neighbors had full opportunity to participate in the hearing below, and I don't see any grounds to present additional testimony. Now, if Mr. Cushman is suggesting that if the applicant were to accept revised conditions, the neighbors would agree not to appeal the decision of this board, I suppose we would have something to talk about. But short of that, I do object. And I would also add that I agree with Ms. Camp that the discussion about the conditions was really inextricably baked into the global discussion of the application and the alternative plan. So I don't want to suggest that they were certainly only applicable to the first story plan. That was really just my impression of the intent at the moment. But you're right, Mr. Chairman, it doesn't matter now, and my client nevertheless is willing to accept them as stated.
Mr. Chairman.
We have an objection before us. My suggestion okay. My suggestion is to overrule the objection. The objection is overruled. Mr. Clifton, please admit this.
I will do so, sir. I would like to call Terry Relic to the stand, please. She is a party to this proceeding. I believe you can stay seated right there.
No, I thought she said.
Is it okay if you sit there?
I'll microphone, whatever.
I believe you've already been a witness and sworn, is that right?
Before.
Yes.
Okay. So could you reintroduce yourself for the record, please?
Terry Relic, I live at 12 Tremont Drive.
Pull the microphone right up to your mouth.
Terry Relic, 12 Tremont Drive,
And spell your last name for me.
R-E-L-I-C-K.
And Ms. Relic, why do you feel it was important to be here tonight?
Well, because the neighbors are very angry that we're at this stage, and
Objection. This testimony has nothing to do with the offer of proof that
It was an introduction.
Well, we'll get it. Overruled.
thank you. We're angry. We're angry, and we feel that this has been an injustice.
Okay. And just to remind everyone, you live in close proximity to the Malvern Institute,
I
correct?
live across the street, directly across 8th Street, not as the judge put in the decision, streets away.
Okay. So I'm going to hand you what I've marked as Relic 1. I did go back through the transcript, and it does not look as though there was an R1. There were some neighbor exhibits. But that was about it. Can you please explain what this exhibit is?
It's police incidents in the last 5 years, taken out of the police blotter that have involved the Malvern Institute.
objection.
Oh,
First of all, the context of the record in this case involves a period of time that ended several years ago when the record was closed. Second of all, information similar to this information was all presented to the board at the time of the hearing. This is duplicative,
no, it isn't.
scandalous, impertinent,
No, it isn't. This is
and
not.
totally irrelevant to this proceeding and to the conditions that are suggested by the township.
Mr. Chairman, the record is clearly not closed. We're here for a hearing tonight, so these proceedings continue. And this goes directly to some of the conditions that were suggested and agreed to by the township and the applicant pertaining to security at the facility. So my client would like to detail.
Well, I don't think there's any question but that we received 2 years ago, similar. Not this report, but reports of incidents that occurred over the same time period. It is, to that extent, duplicative, but I don't see that it's objectionable on that ground.
Mr. Chairman, can I make a suggestion?
Yes.
I mean, If the neighbors wanted to suggest changes to these conditions, I think both the township and the applicant would have been willing to listen to that and potentially come to an agreement. But we don't need testimony about it, we can come to an agreement and tell the zoning hearing board, if you're going to grant relief on one of the plans, these are the agreed upon conditions among all the parties. I think the township is absolutely willing to hear what the changes in the conditions are. Whether the applicant agrees to that, I don't know, but I'm not sure we need testimony on it. And maybe there's an opportunity, not that I want to prolong anything any further, but maybe there's an opportunity, if we had known what changes you wanted, we could talk about it.
Well, if the parties are agreeable to an alternative procedure by which we can come to some final resolution of this, I think the board would go along with that. Mr. Crispin, are you willing to propose your revisions to the conditions to the applicant and the township and see if you can stipulate to them?
I believe that the neighbors have been through a lot in these proceedings, and they have very strong feelings on these, and they would really appreciate the opportunity to be heard on these. And I can tell you, many of these conditions I don't believe are going to be agreeable to the applicant, although I think they are completely necessary. So I feel as though, Mr. Chairman, that would be a waste of the board's time, and if I could just get through this testimony, we could probably be done in 15 minutes.
Well, I don't want to tell you how to try your case, but if this exhibit, R1, is being offered in support of some change to the conditions you're going to describe in a moment, it might be more helpful if you did it the other way around.
All right.
Tell us what you want to change, and then why.
Sure. So preliminarily, with condition number 3, this has to do with the security guard on site during the nighttime shift. I believe the applicant had an objection to that, and so do we. In fact, we believe that there should be a security guard present 24 hours a day, 7 days a week on the facility. I think R1 shows you the vast amount of incidences that occur at this facility, and potentially some of that may be resolved by having additional security present at the facility. In addition, it would help alleviate some of the visitors that the neighbors have in their neighborhood, and the neighbors believe that that would be an important condition to impose on the applicant.
Township has no objection to that.
Mr. Nagel?
Well, I don't think it's fair in this context to ask Mr. Nagel to act on behalf of a client who's not here.
I agree.
Why don't you continue, Mr. Crispin?
What's that?
Why isn't he here?
I agree.
The applicant's case.
If someone had reached out to me, telling me that that was a suggestion, I would have had ample time to process it, talk to my client, and address it. But to ask us to do that here, but the zoning hearing board has come here this evening, is unfair to the board. It's unfair to me and my client. It's unfair to everybody who's here at this proceeding. It should have been done in advance of this proceeding, and easily could have been done.
The neighbors have absolutely no obligation to reach out to you to tell you what kind of case they're going to put on and what changes they're requesting of the board, Brian.
Well, I'm sorry that you want to have your Perry Mason moment, but in these types of proceedings, we communicate with each other. That's how it works.
All right, I think I understand what you both are saying. Mr. Crispin, why don't you continue? What is your next proposal? I understand you've asked that condition number 3 be amended so that it requires not just the security guard during the nighttime shift, but 24 hours a day. That's what you requested.
That is correct.
And you offered in support of that request exhibit R1.
Correct.
All right, continue, please.
Okay. On condition number 2, we do not believe that a letter to the Commonwealth Department of Drug and Alcohol Programming is sufficient to ensure that the applicant will not seek to increase the 80 inpatient capacity in perpetuity, and we would like some form of easement or deed restriction or some way that can be enforced in addition to merely a letter to the Department of Drug and Alcohol Programming.
Well, if it were imposed, it would be a condition of this board which the applicant could violate only on pain of violating the zoning regulations and enforced by the township.
The township fully would intend to enforce it like it does any provision of its zoning ordinance or any other condition of any approval.
As long as that is on the record.
And my client has no intention of going against the commitment to limit the number of patients at the facility in conjunction with this application.
All right, Mr. Fisher, what's next?
May I just say something?
Sure.
In your decision, you wrote in there that applicant has committed to that number for at least 30 years, and then you wrote in parentheses, absent some further relief from the township. So we want to be in there that they can never come back to the township and plead that they're dying on the vine again and that they need more beds.
Thank you. That's an important point. I can't tell you how to act on it, but that is an important distinction.
Okay, the next conditions relate to conditions 6 and 7, and those relate to the 8-foot high fence and landscaping. And if I may, Mr. Chairman, I would like to turn this over to my client so that way she can explain what she would prefer in place of the fencing and landscaping.
Yes, this is the condition that requires all its terms in the fire guard sound wall.
The turnpike fence. That's
So,
let's
and your
call it
position is what, Ms. Rowell?
that the neighbors do not want a turnpike fence, and that we are appalled that the township would even consider that they can have a turnpike fence in a residential neighborhood. 45 feet, is this first story building, but, so it's gonna be right against the property line. And if we're trying to mitigate sound, the fence should be up at the highest elevation to block sound. So a approved upon residential fence, and it has to be installed at the highest point to mitigate the sound. Because even a sound wall, even if a turnpike barrier were put down on the property line, it's not gonna mitigate sound because of how the institute sits at a higher elevation.
Yes, I think we heard testimony on that subject. All right? Next.
The next condition that they
May I interrupt for a second? I think it'd be better if I responded to that as we go rather than trying to catch up later.
Well,
Because
it's my hope that we can get through this. Find out all of the revisions that the neighbors are requesting. And since I don't think you are likely in a position to finally agree to any of them at this point, maybe we'll.
I can tell you that there'd be no objection to
Yeah,
that.
well, I'm not worried about your proposal, that's a town.
Well, it doesn't say a turnpike fence, it's an 8-foot fence to be determined by the board during land development. So obviously there was discussion about that and pictures shown, but ultimately the board has to determine it during land development. And if the neighbors don't want that, then maybe another type of fence can be agreed upon during land development.
And also, if you review the testimony in the exhibits, the fence was cited, I believe, at or near the highest point, so it would achieve maximum sound attenuation. I agree with Ms. Camp.
Then I would request that the neighbors be given the opportunity to have input and a say and veto ability. Because my concern is that they will have.
The neighbors will have that opportunity. They'll have to watch the board's agenda to find out when the land development plan is going to be considered. But that will be done at a public meeting, and they will have the opportunity. They'll also have the opportunity to talk about it before the planning commission.
I understand that, Mr. Chairman, but the fear is that their pleas could fall on deaf ears. And we can put something together right now to make sure that that is not the case.
Well, whatever this board does, it's still going to have to be fleshed out during the land development.
Absolutely.
And I I would also add that I don't believe that Mr. Chrisman represents every neighbor in that neighborhood.
You're right.
So the fence or the wall, whatever you want to call that condition 6 deals with is not just to address the abutting neighbors. I mean, obviously those would be the most impacted, but it's the whole neighborhood.
Yeah,
So
yeah.
sound travels beyond that. So I think we purposely left it that the details of that fencing would be vetted through land development, planning commission, and neighbor input, obviously.
Mr. Chairman, my client would like to make a response to that.
Everybody has always thrown out that only 2 neighbors complain, or only 2 neighbors are a party. And I would like to make it very clear here, because the judge said it also in his decision. When we, as a neighborhood, when there was more people here, when we decided to hire an attorney, we decided as a hire an attorney. We went to Mark Thompson because he was highly recommended. And Mark said, I can't list 60 neighbors. So let's make 2 neighbors a party, 2 or 3, because it's impossible to list everybody. And so that's what we did. That's why there's only 2 parties listed on the agreement. 60 neighbors signed a petition against expansion. 26 neighbors contributed to the legal fees multiple times.
Objection,
So
this
let's
is
just-
going far beyond the context of the conditions discussion.
I think we understand your point, as well as we can see.
Thank you, but I just want you to know that,
The interest has been strong throughout the proceedings,
Yes.
we understand.
yes, but the judge didn't see it that way, so I'm just making it clear. And can I say one other thing? The reason why we want to get this aired out tonight is because the neighbors are preparing to appeal. So we want all this on test, we want this on the record, because the judge totally disregarded everything we said. It was hearsay, we didn't prove it, so this time, we want it on record. So when it goes to a judge on appeal, they're gonna say, there was 26 people that did the, that,
Objection, move to strike.
so.
Again, this is the foundation of my original objection. This is not the purpose of this proceeding, and it is inappropriate for the neighbors to come in with no additional testimony on behalf of the applicant and try to change or alter the record in this case.
I think the record is still open, as I signified earlier, that just based on the fact that we're here tonight, Brian.
I disagree.
Mr. Chrisman, next.
Next is the condition number 13. This is another one of those conditions that some of the neighbors are concerned has no teeth. So if we can get on the record that the township is willing to enforce this condition as well, I think that would go a long way in resolving the concerns of the neighbors.
Township intends to enforce all of these conditions if they're imposed as part of the order.
Just to explain how it works. If this board were to impose these conditions, then they become the zoning of the tract. And that's not a deed restriction, it's not a covenant, but it is the zoning of the tract, which means that the applicant can come back to the board and ask for relief from a condition, but the test is pretty hard. The test is that there are circumstances having to do with the land itself that make the condition inappropriate or unworkable, or it's not just come back and ask for relief. You have a pretty high burden of proof. And I don't know whether that is sufficient for your purposes or not. I suspect it may not be, but that's about all we can do with this.
Mr. Chairman, can I add to that, please?
Yes.
Any condition imposed in the zoning hearing board order can be enforced like a violation of the zoning ordinance provision, which means that there would be a fine of $500. The township potentially could receive a fine of $500 a day for a violation. And Mr. Gordon and I do that all the time with property owners. They're in violation of the ordinance. In fact, we filed a case in court this week trying to collect fines like that. So I'm telling the neighbors that this is not something that we're taking lightly. We wanted these conditions imposed in the order, and any zoning hearing board order that has conditions the township will enforce as the zoning ordinance and the municipality's planning code permit, which is $500 a day in fines and equitable relief to restrain violations.
Next.
Next is condition number 25, that discusses written protocols for responding to neighbors, and that the protocol shall require that a properly trained employee respond to neighbors' calls and advise the neighbors how to respond to a situation. I think preliminarily this admits that there are issues in the neighborhood with residents from the Malvern Institute, but the neighbors are put in an uncomfortable situation. They're the ones that have to negotiate between the Malvern Institute and the person on the phone directing them how to respond. In my opinion, and in the neighbor's opinion, that should be handled by the Malvern Institute, not by the neighbors. They shouldn't have to negotiate what to do. So this protocol needs to have input and say from the neighbors as well. The Malvern Institute shouldn't just be able to create a protocol that requires the neighbors to actively involve themselves in the goings on of these residents.
So you would have, I take it, you would have read, the protocol shall require that a properly trained employee respond to the neighbor's calls. Period.
Exactly.
No objection by the township to that.
Right, next.
Number 26, Mr. Nagel objected to the requirement that this presentation be made at a public meeting. That's concerning in and of itself. I'm not sure how the Board of Supervisors could or should really listen to a presentation such as this outside the public meeting. A public meeting connotes that the neighbors would be able to participate and other residents of the township as well. So we would object to his removal of the public meeting requirement. Okay, and Ms. Ehrlich has one more concern for that one as well.
We continuously call the police and the institute for help and in situations, so we're really not sure if we don't get any help. So we don't get any callbacks from the institute on our complaints. So I'm not really sure, like I was saying, there's no teeth in these, so what are they gonna do? Kristen Camp is saying they're gonna post fines, so when we call and say, there's people outside at 3:45 in the morning in the back of the institute, which we did on June 28th, are they gonna take our word for it? And are they gonna say, okay, we'll impose a fine? They can't make them tear down the expansion, so what teeth do these conditions have? We've been ignored by the township and the police for years, so, so what guarantees does the neighbors have when we call, like we did, a month ago, and never received a call back?
Objection. Move to strike.
Grounds.
Relevance.
Relevant. She's talking about
Excuse me, I'm not finished, Mr. Chrisman. Repetitive testimony and testimony that belies prior testimony that's in the record that the Malvern Institute had been responsive to neighbors in recent times prior to the proceedings.
Oh, yeah.
The objections will receive it as indicating Ms. Relics the reasons for the concern. As to the truth of the specifics, I don't think she was offering to that. So, what I don't understand is how you would have Condition 26 amended. I understand the neighbors wish that the public meeting requirement be reinserted. what else would you ask that we do?
I think it would be prudent to require notice to residents and neighbors within a certain diameter of the meeting that will take place as well.
Township could do that.
All right, next.
There's one more.
If I may have just one moment.
I'm sorry. It should be a phone call.
Okay. All right. Ms. Reynolds would like to articulate one further condition as well.
That would be number 29.
Correct.
It has to do with fines being imposed by the township. Currently, when we call the police, they say there's nothing they can do. And then we show them video, and they say, oh, okay, this is obnoxious, and they will.
Objection, hearsay.
It's not hearsay, we have 2 recordings tonight if you'd like to hear them.
Overruled.
So, my question to you is, we'd like in the incidents, in a condition to say, if the neighbors complain, and we make a phone call to the police, or the institute, and we can document it by our phone records, and the institute is now required to keep records, they should also have it documented. That's proof enough to be fined. Because otherwise, we get nowhere. There has to be some way to hold them accountable. And so that's my point. That should be proof enough of us calling and saying, please bring your people in. It's 3 o'clock in the morning.
I'm not sure I completely understand you, but
I don't know.
if you're suggesting that a patient complaint by a neighbor become a zoning violation, I don't think that's.
No, how are the condition, as the township wrote them, how are they gonna be, what are they gonna ask the township, what are they gonna ask the residents for? If we call and say, it says, the greenhouse is off limits, and there's a time that they can be outside. So when we call at 3 o'clock in the morning and ask them to bring them in because they're spilling profanities, we want that to be enough evidence that we can bring to the township and say, this is results in a fine. Because we have been for 30 years told it's not good enough. So we don't want to have all these conditions with no way of backing them up, with no way, there's no teeth to them. So I would like in the condition to say that all the proof the neighbors need is is that the incident was documented.
I'm sorry, I'm sure it's my failing, but all the proof the neighbors need for what?
To impose a fine.
To impose a fine on Malvern Institute.
For breaking a condition.
Mr. Chairman, if I can respond.
Please.
The way that zoning enforcement works is through neighbor complaints. Mark Gordon has enough to do. He doesn't drive around looking for issues that he can then try to impose fines. What happens is neighbors complain to the township. Mark investigates whether that complaint is in fact a zoning violation. And then if he does, he has to follow the municipality's plan code procedures, which require a notice of violation to be sent. The applicant is given 30 days to abate the violation. And if they don't, we file a complaint in district court and seek a fine of $500. So I think what Mr. Elliott is asking is that when the neighbors complain and say one of these conditions, if they were to be imposed, is being violated, that is all what we need. Mr. Gordon will take that.
He doesn't.
Right now, there are no conditions imposed. There are no conditions imposed on Malvern Institute's use other than what the zoning ordinance provides. So some of the complaints they're talking about The fact that they are investigated and we find that there is no fine that can be imposed does not mean the township is not doing anything. Okay, there are investigations that are made, and oftentimes there is no violation such that a fine can be imposed or a crime can be charged. That is exactly why we want these conditions imposed, so that when they do call, we can in fact start an enforcement process. We're trying to improve the situation by having something that they can hang their hat on and say, Malvern Institute, you agreed to this, you're violating it, Mr. Gordon, go enforce it. We don't have that right now.
That's fine, I just want to make sure we're
Well, I think we've reached some sort of a resolution as to what these conditions will mean if they are imposed. Mr. Preston, is there anything else?
The last condition, it sort of has to do with one of the requests for variance that the applicants submitted to the board, and that is that they retain 12 years after approval to submit a land development application. I think that is absurd, and I think it is within your discretion to change that time period. I don't believe the decision limits you in that as well. The typical, I don't see how they submitted any evidence whatsoever to require 12 years before they actually build this expansion if they do so.
I have to say, Mr. Mayor, that was a question of mine. Do you still need 12 years if you're not going to be implementing the one-story plan?
Well, one of the conditions requires my client to proceed with the installation of a number of renovations before they can even obtain a building permit. So I think the answer is yes, out of abundance of caution. My client is asking for some time to go through the proceeding, but certainly my client needs to proceed with this as soon as possible. So I don't really foresee a situation where 12 years is ultimately going to play out if we need to answer your question.
Mr. Chairman, if I may, an abundance of caution is not the standard for variance, particularly for 12 years for variance to stand. I think that the time period set forth in the MPC and the township zoning ordinance are adequate, and I do believe that your ordinance permits the zoning hearing board to authorize if the applicant were to so need one. And so we would suggest that you use that provision and allow them to come back and request an extension if necessary.
I think condition 28 addresses this, and if the 12 years is off the table if they comply with condition 28, which says that they have to obtain a building permit for the building addition within 3 years from the date of the unappealable zoning decision, and they have to obtain a building permit for the barn renovations within 4 years.
Right, and that would vary the normal 18-month period.
Yeah.
And Mr. Chairman, we don't believe that that's necessary, so I apologize. We should have asked for that condition to be stricken instead of adding a condition further. Your ordinance permits the applicant to come back and request an extension of time, and I don't see any evidence as to why the applicant here can't comply with your ordinance and that a variance is required.
All right, is there anything else?
Mr. Chairman, there are various neighbors here who would like to have some comment as well, if you will permit them.
I don't think that's the purpose of tonight's hearing. We heard 6 nights of testimony about the 2 proposals and the neighbors' objections to them. I think we're very cognizant of the neighbors' positions, but more importantly, for your purposes, I think that's all on the record. That's all in this case. The fact that Judge Cannell didn't give it much credence is not the end of the analysis. I would suggest that I turn it over to my colleagues, but I would suggest that we not allow additional testimony. I don't think that's all. Anything else from the applicant?
No, thank you.
Anything else from the township?
Nothing further, thank you.
My suggestion would be that we'll close this record tonight. I thank you all for coming here. I appreciate your attention and your involvement. I think we understand as a board where you're coming from, your concerns. I think we addressed those concerns in the decision we wrote.
You did, thank you.
Thank you.
I would say to the applicant and the township that I'm very aware of all the work that was done on the revised proposal. The work by township staff, the work by the planning commission, the work by the solicitor, by the applicant. We appreciate all of that. And there's no doubt in my mind that it was all done with a good intent and that the plan is in the public interest. But I want to say this as clearly as I can. All the public interest reasons in the world don't add up to a reason to grant a variance. If the township wants to pursue the revised proposal, in my view, and this is my view, the way to do that would be to amend the ordinance. We can't amend the ordinance. That's not within our power. So for that reason, I'm glad we've gotten to this point. We're back to the original proposal, which is within the power of this board to grant. And I will make a motion that we grant the original proposal subject to the conditions as they were agreed to be amended, including a revision to condition number 3 requiring a security guard 24 hours.
Mr. Chairman, if I may, I apologize. Just to be clear, are you removing that sentence from condition 3 in your approval? Is that what you're stating? Oh.
No, I was revising the requirement for a security guard on site during the nighttime shift, one for 20,
Okay.
Security guard for 24 hours.
Thank you.
Deleting condition number 4. Requiring in condition number 6 that the neighbors be notified of when the land development plan showing the wall is to be considered by the planning commission and the supervisors so they can participate in that proceeding. Leaving condition 26 as it is, that is requiring that the annual presentation is be made at a public meeting. I'm sorry, revising condition number 25 so that the second sentence reads, this protocol shall require that a properly trained employee respond to neighbors' calls, period. And that all the other conditions, numbers 1 through 28, apart from those amendments and deletions that I just described, be imposed as conditions to approval of the original proposal. I make that as a motion, like the second.
Second.
The motion has been seconded. How do you vote?
I vote in favor of the motion.
Motion carried. This board will enter a decision in due course, a written decision. We've been instructed to do that by the court, and we will do that. In the meantime, I would ask the parties to have the communications they haven't had up till now, for whatever reason, and to attempt to come to some agreement as to how these conditions can be amended to all of your satisfaction. Otherwise, the motion will be carried out in the decision.
Mr. Chairman, if I may point out, I'm not sure whether the normal time constraints under the MPC apply, but if to the extent that they do, I'd like every council of record to agree to waive the time periods for the board to issue a written decision.
Township has no objection.
The neighbors have no objection.
No objection.
Thank you.
Any other business before the board?
I have a request for clarification. With respect to condition number 3, Mr. Chairman, there was a discussion about the security guard being a MOAB trained technician who trained in security, but is trained specifically to work with the patient population that my client serves. And you mentioned with the accepted revision, that was the revision that the township did accept. Is that still included as a revision?
Mr. Nagle, I didn't make that revision because I think you're giving security guard a technical meaning that it doesn't have in my view.
Fair
You
enough.
tell me that a co-ed trained employee is a security guard, unless the township thinks that that's a violation of this condition, I think that will pass.
Fair enough.
Any other business before this board? Thank you all for coming out. We're done.
Thank you.
Where is this?
No,